Hey, welcome to Hold My Briefcase, where we explore legal issues that you can learn in order to help yourself. Learn the little legal tricks and secrets. Today, we're talking with my friend Clark Martin, owner, founder, manager of the Martin Law Firm. Did I get that right, Clark?
Yes, sounds right.
So we're going to be talking today. Clark does a lot of things, but I think the best value added that people can have is learning to deal with probate. And so Clark's going to actually show you how a pen and paper will can work and why that little piece of paper can explode into months of probate if you do it yourself wrong. So Clark's going to show you how you can use a pen and paper, no lawyer required, in order to make a will. Stay tuned.
And
I'm
we're back.
Clark, and we're back. Are we supposed to do commercials?
Yeah, now a word for our sponsor.
This is now a word from our sponsor. Are you tired of your content being boring? All right, so kind of set the stage. 68% of Americans, and survey after survey, only a third of people have estate plans. Why do people keep kicking the can down the road, Clark?
I don't know. Well, I think it's two of probably many things, but two that come to mind are people, to some extent, don't like thinking about their own death, their own mortality, and what to do with what they have, who it's going to go to. These are decisions that have to be made, and why think about it today when you can think about it tomorrow? Because I'm going to live to be 100, right?
Right.
Every day is guaranteed to everybody.
Every day.
They think they're going to live to 100. A lot of people get, a terminal disease, or they're in a tragic accident, or before they know it, they're slowly losing cognitive ability. Now they can't
Yeah.
draft a will. And it's a slow roll, something they're just not thinking about. I think another major reason is because people misunderstand what estate planning is. Most of the time when you hear the word estate used, you're thinking of an estate. Like, wow, acres, a mansion, cars, bank accounts, like this is an estate. But the fact is everybody has an estate. It's just the degree of size.
Now, estate planning does sound very intimidating. I'm a lawyer. I passed the bar, and I still am intimidated. In full disclosure, I only have a very simple will.
That's because you're not a very good lawyer. I'm kidding.
That's so funny.
Colby used to
So,
be my boss.
yeah. So speaking of that, let's give everybody a little background about Clark Martin. Clark, where did you grow up?
Houston. I grew up here in Houston. If you're from Houston, I grew up in Spring. If you're not from Houston, I grew up in Houston.
And you've stayed in Houston all your life?
Yeah, except for college. I went to San Marcos, and that was the best 5 years of college of my life. And then came back to Houston for law school, and I've been here ever since.
And you didn't take the usual track. You actually started a law firm relatively early. Now, did you work for big law before and you didn't like it?
Well, you were there. So yeah, right out of law school, right after I passed the bar, I did open up my own firm. I knew I always wanted to do that. I didn't know exactly what I wanted to do. Um, but also I was a realist in the sense that, like, hey, I probably should get a job, um, first to get some experience and, learn what's happening. And I used to work offshore. And so the job that I ended up getting was for a maritime defense firm. And I was a bit at odds with my boss and the culture of that firm, because I used to work offshore as a blue collar offshore worker. And they were defending big companies that have projects offshore. So when I would see that a plaintiff was injured, um, somebody that I would have been, right, blue collar, regular worker, when I saw that somebody was injured and I saw the facts around how they got injured, I could immediately identify that this absolutely happened. Because I've been there before. I've seen project coordinators for big companies intentionally cut corners and tell workers to cut corners, they get injured. But of course, I'm supposed to be defending these companies, and it didn't sit well with me, and it showed. Um, Colby was my supervisor, and after I'd left there, he and I maintained our friendship, and we're still
Yeah.
today.
Yeah.
Yeah,
Yeah. And, that was such a great experience for me to supervise you. uh, yeah, I remember the boss, the partner being like, "What's wrong with that guy? He doesn't seem very chipper." And I'm like, I don't like his haircut. Maybe you could talk to him about getting a normal haircut." So they sent me in to talk to you about what a professional haircut should be and the importance of showing up on time and looking a certain way and wearing a suit and tie. As you can tell, that still kind of sticks with me. And Clark, you got out early. Unfortunately, I stuck around for a while, made a partner, and then I followed you when I created my own law firm 10 years ago, but your law firm's been around for how many years?
15. I mean, it's not that much
15.
longer.
15 years. And you've been practicing since
2011.
wow.
Yeah,
And,
15 years. Is that
it's
yeah?
just a challenge, I'm sure. The 2011? Yeah, okay.
Lawyers don't do math.
Yeah. And to be fair, you do a lot of things with your law firm. You take care of a lot of people in different ways, isn't that right?
Yeah, I hope so.
Well, what I mean is you do personal injury
Right. Yeah.
and you do probate
And estate planning.
and estate planning. And
Right.
today we're talking to you about your estate planning and probate, and we could talk about personal injury some other time. Why do you handle probate?
I like it.
Why?
I mean, that's really it. I enjoy it because I wanted to be a lawyer to help people, and people need help when somebody dies. I mean, look, let's be honest. Most of the time, if it's a probate, it's their parent, and you have, some people have two parents, people have one. But the bottom line is when the first parent dies, you're in a situation you've never been in before. And you can look at your peers who are likely the same age as you. They may have never gone through it either. So what do? You have this, if you still have another parent that's alive, then it's not as difficult because typically the whole estate is going to pass to the surviving spouse. But if there isn't a spouse, um, then what do? You have this house possibly with a mortgage. What if you have multiple properties? Which one's the homestead? Are there exempt assets? What's non-exempt assets? What about retirement accounts? What about? And it's just kind of the list goes on.
So if I'm hearing you correctly, when a person dies in Texas, there is a process by which the estate, and the estate is just a fancy term for everything you owe. If you're to pile everything up into a pile and then pile up all the debts, whatever's left over is your estate. Is that kind of a basic way of looking at it?
Yeah, I agree with that. And in this conversation, just as a disclaimer, everything we're talking about is kind of in generalities.
But yeah, we're going to get to that disclaimer at the
Okay.
end. Don't worry.
I mean, based off of what you just said, I could talk for 15 minutes about intricacies, but I'm just gonna go ahead and be like, yeah, generally I think that's a great way to put it. Yeah,
Yeah, and that kind of
yeah.
sets the table for, what happens when you die. And you can die with a will or without a will,
Hmm.
right?
Hmm. Right.
It's kind of like pregnant or not pregnant. You either have a will or you don't have a will.
True.
So explain to me the process of if you have a will, and I think that's decedent's will. Decedent is a fancy name for the person who died,
Yes.
right?
Yeah.
I love this lawyer language. They can't just say person who died or guy who died. They got to say decedent. And heirs, is that how you say that? Heirs?
No.
Heirs? Heirs?
Heirs.
Heirs?
It's like herb.
Herb?
Yeah.
Or whores de gores?
Or
I like
or
some
divorce.
whores de gores, please.
Yeah.
Yeah. So your heir, is the person collecting the estate, right? Okay, I'm sorry. The decedent's will identifies the heirs. It deals with paying valid debts and transferring money to rightful beneficiaries. Kinda.
Kind of. So, just for a little bit of clarity, right? You have the executor or the administrator. That's the person who is handling the will. Okay. You
Handling.
handling. They're the ones who are basically um, probating the will and making sure the will is followed. Right. The wishes of the decedent are followed. Uh,
Hmm.
now there are two ways that can go, but if there's a will, there are heirs, and an heir is somebody who is related to the decedent,
Mm,
typically downward. Okay, so
got it.
child, grandchild, those are heirs. If you don't have children, an heir could be brother, sister, and if you don't have anything, and you just have a parent, they can be your heir.
So, like in Game of Thrones sense, like it's like the king and the bloodline. That's an
Yeah, yeah, like
heir, as you
yeah, it's
said.
like heir to the throne, right?
Yeah, yeah, that's
Um,
how I've heard it used before.
and if you think about who's the heir to the throne, there is a succession, and Prince William is king, but then if Prince William dies, Harry takes over. Now, if Harry dies, then you're going to look at who's next in line. Well, I don't know, who is that. Does who's the king now? Charles.
George? Prince George?
George.
George?
That
Is that
tyrant.
George?
Like King Charles, you'd look to see, like, okay, well, does he have any brothers or sisters? I don't know the answer to that, but then they would become um, king or queen.
Got it. So that's why it's so important to murder your heirs.
That's right.
Understood.
Yeah, that's exactly right.
Regicide. Brought to you by Martin Law
Yeah,
Firm.
the red wedding. Um, so those are heirs, right? And just because you're an heir in some way or some degree doesn't mean that you're necessarily a beneficiary.
Yeah, they could not like you, and there's nothing you can do, right?
Well, I mean, it depends. Have you been specifically left out of the will for a reason? Um, a lot of times, when you draft a will, you're going to draft. Let's say you are married and you have two children, and you have four grandchildren. You may draft your will in a way that says everything goes to my wife. If my wife has died, then everything goes to my children in equal shares. But if one of my children have died, then it goes to my child half, and then the other half is split between the grandchildren. Right? In those instances, if everybody's alive, somebody's going to take per your wishes. Now, let's say both your children have died, your parents are dead, your wife is dead, and all your grandchildren are dead. And that's as far as your contingencies went within your will. Then then what will happen is the court will look at your heirs at law. So everything will go to what's called the residual of your estate, and then they'll find, okay, who are your next heirs that weren't, these people aren't qualified, so who's next? And then so they'll look at your family tree, or they'll get some type of testimony witness as to your heirship.
Remember a term from law school, sanguinity or something like that? Is How do you say that word? Are we going to have to?
Sanguine. I've never said it. I've only read it, and I've never said it because every time I read it, I'm like, wait, how do you say that? And I've never heard anybody say it either.
I know. There's so many words like that in law school
Yeah.
where you like open your mouth and everybody knows you have never spoken this word before. But that's like the line, right? It's the statutory line where, this is the one, then this one, then this one, then this one. It's kind of prescribed so you don't go from, you died to the 12th cousin 15 times removed. Is that accurate? Or am I making that up?
I mean, you've seen like so this is I'm really reaching far back. The movie King Ralph with John Goodman. Remember that?
Yeah,
You
yeah, yeah.
remember that. He's an American guy, and the whole royal family gets together to take a photo, and they're standing in water, and like an electrical current comes through and kills
Yes. Zap.
the entire royal family. And so King Ralph like gets a knock on his door that's like, "Hey, you're next in line." Okay, that's hilarious, by the way. But but if you take that and look at it as like in a probate matter, if your entire lineage dies and there is one person that we can track somehow, then they're going to be the beneficiary, more than likely. Now, if there's absolutely nobody, like that's it, your bloodline is gone, it's done. Then it is teach to the state. So
Yeah, and it doesn't default to the state. And if I remember, the philosophical reason was that, we own the capital, we own the property, we own the estate, and that ownership doesn't die just because the owner dies, right? Otherwise, we would the all of the capital and all the property would just be a constant flux where nobody could write any contracts for longer than 10 years, because you never know what's going to happen. Now, walk us through like day zero to final distribution from with an estate. I've read someplace that a will must be filed for probate within 4 years of death, or the estate is treated as intestate for most purposes. Can you
no,
explain
it's
that?
kind of like a statute of limitations. Now, I've done, and I don't even know how many probates I've done. A lot.
You've seen things, right, Clark? You've got the 100-yard
Yeah.
stare.
Yeah, it was 2020. It had just struck. We were dropping
Oh
back from.
gosh, pre-COVID, post-COVID.
I forgot. Oh, in the hundreds for sure. But anyway, enough about me. What was your question?
uh, um,
From day zero.
walk us through like a day zero to final distribution. What are some of the major choke points? And I have here, like, you have an application and citation to interested parties. And then you have a court hearing to admit the will and appoint a personal representative. And then issuance of letters testamentary, or letters of administration if no will. What are these first three steps?
So to go back to what you said, yes, you have 4 years to, I'll say, bring the action, right? File the application. Over. That's why I was talking about how many I've done. Out of all the cases I've done, I've had a lot that have been past the 4 year mark. I've had applications that were filing in 2023, and the death happened in 2009. I've never had a court ever hold up a probate because of the 4 year rule. Now, we always have a reason why it's been late, and it could have been because the estate had no assets, but then suddenly it came into assets because some long lawsuit just settled. Okay, so
Mm.
like typically that's why it's going to take so long. Um, I mean, I've even told the court, "Hey, look, my client had no idea that they had to do this." The court goes,
And
"Okay,
that's
yeah,
that's the difference between maybe going pro se, which is a Latin term for going it alone, doing it yourself, and doing it with an attorney. The attorney, has the relationships and the pragmatic ideas where they can work through problems. Is that fair to say?
yeah, I think so." And we usually have a pretty good rapport with the clerks. Um, but what will happen is you'll get the phone call and somebody doesn't know what to do. And so
Mm.
to get the core information, the first thing that we need, if there's a will, we need the original will. Like I have
Why
to,
the original will?
because, and I don't know how the courts test it, but somehow they test it and they know, like they're good. They can sniff this out. Like this is a copy. You're like, damn, how did you know that? It's like, I mean, or this is an original. They want the original will because that's what it is. They have a protocol and procedure for how to probate a copy of a will. So if you have just the copy, that's okay. We just need to go through an extra step. But they,
So just to put a pin in that right there, it sounds like making sure your will is in a secure place is an important step. Is that correct?
yes.
Where are some of the places you've heard about people storing their wills that are just head shakers?
Well, that's hard to say because I wouldn't know because they haven't found the wills, right? Like
Yeah.
anytime, yeah, anytime I come across somebody who goes, I know there's a will, I can't find it. Well, obviously, they weren't storing it in a good place because who knows where it went.
I
But
it
typically,
seems like it.
safety deposit box, or they have it in they have a desk at home where they have a filing cabinet or something. Sometimes they leave it with lawyers, but I would never, ever, ever, ever rely on that.
You sound pretty certain about that.
Yes, never rely on an attorney having your original will.
Yeah, I've heard about people putting them in their family Bibles. I've heard about people putting them in a on a bookshelf. I have told people to make a really fancy binder that looks really nice and put on their bookshelf. And basically, if something were to happen, bam,
Mhm.
here's all the documents you need. And Clark, you make those documents too, right?
Yes, yeah.
What is a letter letter testamentary? Testamentary. God, I hate probate law. Testamentary. What is that?
Um, well, let me get to that. So
Sorry, bro.
no, no, it's well because you said from day zero.
Oh, yeah, yeah. Yeah.
So you file your application, and then the clerk will either automatically or you have to request them to issue citation, and that just goes into the legal newspaper. And then once citation's been issued, you're going to file the original will. Where I'm actually going to mail the original will to the courthouse. If it's a copy, I'll just upload it. The death certificate, I'll need that, and I'll file that with the court. And then, of course, it depends. Right now we're talking about a will, so um, if everything's buttoned up, then we're going to wait to see um, if the court gives us the thumbs up, everything looks good. Because a lot of times there's a staff attorney, and the staff attorney is checking the filing attorney's work to make sure everything's good. Because you don't want to have a hearing and then nothing's right. And once you get the thumbs up, you just schedule a hearing. Um, you go through the process of asking the executor questions. They get appointed as the executor, assuming there's no issues. Now, if there are multiple beneficiaries, you do have to give them notice, see if they'll sign a waiver. And once they become the executor, you file what's called an inventory with the court, and that lets the court know, these are all the assets of the estate, and they'll get signed off by the court. Then the executor can go and distribute the assets of the estate per the will, the direction of the will.
And then once that's all done, you close the estate.
Right.
Is
And
that then? Does that get filed or anything like that?
yeah, it's everything's filed with the court. I mean, there are other things in there. You give creditors notice and everybody ample time to respond. Most of the time, I creditors just don't do anything.
I've got some fancy Texas probate proceeding procedures. Can you tell me what it means when they're doing an independent administration?
An independent administration is typically done when there's no will. And what will happen is the administrator, the person who is filing the application for heirship and for administration, what they're doing is they're asking the court to please appoint them as the administrator independently, meaning with very little court supervision.
And is it true that this is the most common?
Yeah, absolutely. Among people without wills, 100%. Um,
And
but the alternative is dependent administration, and
explain that.
that is when you're somebody's applying to be the administrator, but there is a lot of court supervision. So that means every single thing that the administrator wants to do once being appointed has to be approved by the court. And that typically will happen if um, beneficiaries or heirs are fighting,
Mm.
or it's a
What would
very complex estate.
you hear about these things all the time, like the Anna Nicole Smith, which I was told was the Super Bowl for probate litigation, as far as how long it took and the amount of money. But I understand just recently why it's called a will, because it's trying to trying to make the will of the person who died go through, right? It's their will, right? I never actually put two and two together there. So if it's their will, why would anybody fight it? I mean, what right do you have to come in and say,
Mm. Um, because people are terrible. I mean, that's the bottom line. People are inherently selfish, and that's just it. They they feel like they are deserving of something that's not theirs by means of just being offspring, perhaps, or the dear brother.
Mm,
But what you find a lot of times is that the beneficiaries slash heirs who are challenging things, they're usually pretty terrible people. Um, Exception would be where there is clear evidence of undue influence or coercion or some type of fraud, which means that somebody, usually the beneficiary that's getting the most, has worked their little tentacles into the person who's about to die and has gotten them to draft a will completely in their favor. And perhaps that person is a caretaker or somebody that lives with them, but they have unbelievable influence over their decision making. In those
mm.
instances, um, yeah, that heir should be challenging what's going on.
Is that a easy challenge to make? Just walk in and say, mentis non compos, or, you know, that was his mistress. I mean, is it easy to do?
I mean, it's easy to make the allegation,
Is it easy to overturn the
but
will?
then you got to back it up. You got to have some evidence, and
Mm.
I mean, it's like anything. Then maybe there's some type of settlement or agreement, or it goes to trial, and then it's up to a jury. Hey, do you, based off of this evidence, is it more likely than not that this person unduly influenced this person? Now,
Hmm.
so if the will gets kicked, booted, you may be dealing with a complete, the will being completely invalidated. At which point now you're going back and you're having to probate the estate as if there was no will.
Do you see
You yawning.
executor?
Like, how much fun? How interesting is this?
Oh, it's just oh, I'm sorry. I got my tea here. I haven't had coffee yet. No, you've dealt with executors before, right? What are the top three mistakes you see executors make?
The number one mistake that executors make is not getting me the information that I need, because I need certain information. I need it at the beginning, but at the same time, I'm not I'm not your dad. You know, I'm not going to call you every day. Hey, did you get that stuff? At some point, you're going to get it or you're not. Uh, that's the biggest mistake, because then they get frustrated. Like, this is taking too long. It's like, well, I'm waiting on you.
Yeah, that's always the thing. Somebody's waiting on a thing. Did you get that thing? I got that thing. Can
Yeah,
I get that thing?
I forwarded you that thing.
I forwarded you that thing.
So that's the first. That's the first thing that I see. The second is them. Look, they don't know what's going on, so they have high anxiety. And what I wish that I could take from them is, like, there's nothing to be anxious about, especially before a hearing, right? When we go into a hearing, they get very nervous about the questions that are going to happen. And the thing I tell them is this: if there was going to be somebody challenging this, we would know by now. Okay, if somebody were to challenge this, we would know. Right now, we're going into a hearing where everybody wants this to work. I want this to work. The judge wants this to work. If there's an ad litem, they want it to work. Your witnesses want it to work. Everybody wants this to work. You have no adversary. So there's nothing to worry about. And worst case scenario is the judge asks a question that needs some clarification that perhaps you don't know the answer to. Very rarely ever happens. And if it does, then we just get the answer and we come back. No big deal. So yeah, the anxiety, that's probably the second one. And then the third one is just not letting the process go, because look, courts are backed up, timelines have to happen. You could get a bad ad litem that's just taking forever. You could get bad witnesses. It could be the client that's bad. It's just factors.
How can hiring an attorney early actually save money?
I mean, it would save money in the sense that they don't have to go back and undo everything that you did wrong, which takes time.
Well, I mean,
Which takes time,
it's kind of
and also has probably pissed off the court. Like, the court knows you, and they probably know you. Like, when I say you, I mean the client. They know you. They know that you're trying to do this on your own. They know that you're calling all the time. Whoa. Your eyebrow?
we'll edit that out in post.
Leave it in. Hey,
Leave it in.
question. Did you, like, take a zinc on an empty stomach or something?
Oh yeah, I took this ADD medicine that sometimes takes me a couple minutes to. It's like I get heat up and then my stomach just says, "Screw you." Whew. It'll take me a second just to.
Yeah. The zinc
You do
thing.
zinc?
Sometimes, but that I know the zinc feeling is not good.
Yeah, I think it's Stratera or whatever, but there's a specific combination I haven't been able to master yet, where it's like caffeine plus the drug kind of makes me too much.
Yeah.
So I thought with the green tea it'd be okay. All right. So
Yeah, I don't even remember what we were talking about.
I do.
Okay.
You were talking about probate, Clark. Obviously, you're talking about probate and how having a lawyer at the front is beneficial and can save you money. And the issue with most people when it comes to money is, they just had a relative die. How are they going to pay for a lawyer? How do they do that? Does it come out of the estate? Do they have to pay you up front? How does that work?
I mean, it can work a lot of different ways. One way, some lawyers do a flat fee. Typically, you're only going to see that for an administration or a probate of an estate where there's no contest, right? Nobody's contesting anything. And typically, if it changes into an estate where there's somebody's contesting it, then the terms will change. But some people do that, and some people ask for the payment up front. Some people ask for it on the back end. But in any event, you don't know what the expenses are till the end.
Mm-hmm.
Other people will do a retainer and hourly.
Okay.
Most people do that. So, hey, look, This has to be done. You are going to benefit from this. There's credit cards. There's all types of stuff that you can do to pay for it. But you can get reimbursed from the estate. I mean, that is
So the estate if can reimburse you for the lawyer, so you wouldn't be out anything.
that's correct.
But that's after the estate is probated, right? Okay. Now you all have to deal with all the parties as the person dealing with the probate. So siblings, other parents, stuff like that. Have you had to be a therapist or a counselor?
Typically, that only happens when there is a dispute, and it's not a good spot to be in. I mean, I've been able to really avoid and navigate away from those um, as I've been the longer I've been a lawyer, just creating boundaries. But at the
Mm-hmm.
very beginning, um, I I didn't think anything about creating boundaries, and it became as if like I was a part of their family, trying to resolve, whose bull impregnated what cow and who has what interest in what heifer, and all the brothers and sisters hated each other, and so it took. I ended up actually referring that case to a litigating probate attorney. I mean, this was like 2012, so I was very wet behind the ears.
Mm-hmm.
And I received a notice in 2021 from the probate court that case was still going.
Oh my gosh, that's awful. Years and years of fighting.
But the thing is, like, I know because I was there that it has nothing to do with the lawyers. It has nothing to do with the courts. It was
Mm-hmm.
that this family cannot agree on anything. And the thing that's frustrating that you want to try to explain to them is you're spending the entire amount of money from this estate on trying to figure this out. They probably spent more money trying to figure out the estate than what the estate's worth.
Mm.
It's all out of vindictiveness. You know, suggestion to any lawyer that's listening: don't take those cases. Just don't. I would. I mean, I would. If I see that red flag, I'm done. You can go hire another lawyer.
Yeah, I mean, as lawyers, we have to look for red flags. We have to be protective because, you know, we don't want to get involved in, a family dispute that we can never resolve, no matter how good of an advocate we are. And speaking of being an advocate, when they hire you, you're the one who goes to court, not them, right?
Um, no, they also go to court, but
Oh,
because I have to ask them questions. It's like I have to prove up the case. I have to prove up that who they are is who they are, and that they're qualified to act as the executor or the administrator. And so I ask them a series of questions, and they answer it, before the judge, and also gives the judge the opportunity to ask some questions. If there's not a will involved, the ad litem gets to ask some questions. Um, and we may have to ask questions of witnesses as well. And that's just to prove, are the heirs accurate? Do we have the right, brothers and sisters and daughters and sons and everybody who's involved? Um, but the good thing that came out of COVID was that this is all pretty much done by Zoom. With some exceptions, small counties do it still in person.
yeah.
Um,
Yeah, I've got to go to some counties all the time.
Yeah, like it's just some county you don't even know exists. Usually, so you got to do those in person. Super nice people.
Hmm.
It's never really a problem. But your bigger cities, um, yeah, it's going to be Zoom.
And at the top of this, we are talking about a holographic will, remember? And this is a will that is different under Texas law. Is that correct?
Yes, I mean a lot of states have some holographic law rules, but yeah, Texas is
What is, oh, go ahead. I'm sorry.
no, I was just saying Texas is one of them.
Yeah. What is a holographic will? It sounds like some. sort of Star Trek thing.
Yeah, I'm more of a Star Wars guy, but yeah, sure, I see what you're saying. Uh,
Oh, come on. Star Wars. Star Trek had actual science and like something you could, they're still finding out like warp speed, warp engines. It might have some reality to it, but I
Dress.
digress, digress, or whatever. I digress. Holographic will
Yeah, so
define.
holographic will. It's basically a will that is in the handwriting of the testator. That's the person who's writing the will, which has to be the person who's right.
Holographic is writing.
So if I wanted to do a holographic will, it would have to be entirely in my handwriting. No typing or anything.
Mm-hmm.
I'd have to, be clear that it is me, that this is my last will and testament. It's best to say that you're revoking any prior wills. It needs to be signed by you. It must be dated. That's very important. It needs to show that this is your intent to dispose of all of your property, your assets. And you designate beneficiaries, right? Who gets what. That's really the long and short of it. It's not the best way to do a will.
It's actually quite frowned upon in Texas and any probate lawyer. Why is that?
Well, one thing about the holographic will is you don't have to have any witnesses sign it with you. Now, typically, you're going to have a court they're going to want you being the administrator, the executor, the applicant, to prove the handwriting, right? And you just do that through witnesses, people who knew that person. So that's an extra step. But the biggest thing is like, look, I can't read my own handwriting half the time. So
There it is. There's the pragmatic point.
yeah, so people probably can't read your handwriting. God forbid you did it in pencil and it faded, or you did it in pen. You did it in pen and it got wet and it smudges, or you know, um, or you're handwriting this means you're not using a lawyer. You're probably not a lawyer. You're not using a lawyer. It's not being reviewed by a lawyer. So you're likely not disposing of all your property properly. There's probably a lot of ambiguity in what you want. Although wills are highly customizable, there are a lot of things that just don't work by putting it in a will. And anytime you have that area of ambiguity, that is an opening for somebody to come in and say, this is a bullshit will.
We'll beep that out.
Oh, BS will.
We're
And
gonna the two viewers that are gonna see this are gonna be offended.
yeah, how dare. Uh, the other issue is because there are no witnesses, it leaves an opening for somebody to attack the testator's cognitive state, their mental state, right? If you have
It's
two
11
witnesses,
o'clock.
if you have two witnesses and they sign, it's easy to call them and go, yeah, I was right there when he signed, and then I signed it. We had an hour conversation before, we had an hour conversation afterwards. This dude knew exactly what he was doing. There's no question about it.
And so the long and short of it is if somebody needs help, they need to speak to a lawyer. Usually it's going to be the best bet going forward. And if they need to speak to a lawyer about probate, you will take their call and give them at least a consultation.
Sure, yeah.
Let them know, if what they're doing is right, and try to, see if it's going to be a right fit. And to get that consultation, all they have to do is contact you, right? Tell us more about the initial consultation real quick.
Essentially, this for probate, not estate, right? Okay. Typically, it's just going to be, who are you, right? What is your relation to this person? Were you named in the will as the executor? If so, boom, we're ready to go. If there's a will and somebody was named as the executor and it's not you, hey, this is none of your business right now, unless you're calling me to say this will was signed under undue influence or something like that. You want to challenge or attack the will, and that's a different story. But if you're just trying to probate the estate, yeah, this doesn't involve you. If there's no will and you have some relation to the decedent, then sure, we can do this. I mean, really, anybody that has any interest in the estate can bring the go for your fall asleep.
We'll edit that out in post.
Okay.
I think it's the damn reaction I'm having.
Are you feeling like flush, like flashes of flush, red, like heat?
Yeah, it's like hot and then tired. I don't know. It's okay. I appreciate you putting up with me. I didn't want to reschedule this because I was real excited about doing this with you.
Are you not
Uh,
are you not feeling good today? Like just generally?
well, no, I mean, I did just vomit.
Yeah, but you said it was because of like medication or something.
Yeah, it comes in a wave. So
Okay.
like in an hour or two, I'm going to be fine. But so let's get some catchphrases for you. If you're staring at a probate clerk's rejection letter or want to avoid one, book a strategy call with Clark. He and the Martin Law Firm will be there to answer your questions and ultimately steer you through any obstacles that may be in your way. Clark, if folks remember one thing about probate from today, what should it be?
That it's not a scary process.
And
Everybody,
listeners can find you on your website, and that website has a nice picture of you, and it's, what is it, Clark Martin, Walter Martin. I love that. Walter Martin Law. True story. That's your real name, right?
that is well. Clark's also my real name.
Oh,
Because
you have
Walter is my.
two real
No,
names.
I have three first names: Walter, Clark, Martin.
Yeah, and I love the Martin. So if when we're thinking about getting together, it's Martin and Lewis or Lewis and Clark. Everybody loves Lewis and Clark for
Well, yeah,
some
I mean, that
reason.
just makes
That's
sense.
just cool.
Yeah, it makes sense.
Yeah. So I really appreciate, Clark, you coming in today. I hope this is the first of many topics that we're going to be able to talk to people about. As always, thank you for speaking with us. And this is Colby with Hold My Briefcase. I really appreciate you listening in today, and I'll talk to you soon. If I can find the stop button. Okay, so out of all that.